"This is a courtroom, not a circus," the judge warned, slamming his gavel. I didn't blink. "No," I said. "It became a circus when you allowed a teenager to be interrogated without legal counsel. Gasps, murmurs, the kind that ripple when truth hits a room full of liars." The judge snapped, "Stop playing lawyer." I looked him straight in the eye. "And stop pretending I'm too naive to know my rights." That was the moment everything changed. They wanted silence. I gave them a legal earthquake. They thought I was nobody. A scared little girl who stumbled into a courtroom with dirt on her sneakers and too much silence behind her eyes. They didn't see me as someone to fear, someone to respect, hell, someone even worth listening to. I could feel it before I even stepped through the double doors of the Jefferson County Courthouse. That thick, southern kind of judgment that hangs in the air like humidity. No one said it out loud, but every look told me, you don't belong here. That's the thing about being underestimated. People mistake silence for weakness. They see youth and skin color like they're criminal evidence. That day, I let them believe all of it. Have you ever been judged, discriminated against, or had your dignity and self-worth completely crushed? Let me tell you my story, the pain I've had to endure, and everything I've been through. If this speaks to you, leave a comment with the number 9 so I know you're with me and ready to hear what I have to share. And don't forget to like this video and subscribe so you won't miss any of the intense moments ahead. If you're deaf or have trouble seeing, please turn on the subtitles. We created them especially for you, because you matter. This is Radio from Hine, the #1 YouTube channel for justice and equality for everyone, standing strong against racism and discrimination. Wishing you a peaceful day. The courtroom was fuller than I expected. For a pre-trial hearing, it looked like half the county decided to show up. Maybe word got out. A teenage girl accused of stealing proprietary data from a local tech firm. They made it sound like I hacked into a government vault. In truth, all I did was help a friend erase metadata from a private video. She didn't want her ex tracking her. But the file was tied to the wrong client, the wrong company, and the wrong political donor. That's how I ended up here. The room smelled like old wood and recycled air. My sneakers squeaked a little on the floor, and heads turned. A few whispers floated through the air. I didn't flinch. I'd worn my best. Black slacks, white button-down shirt, my mother's old pearl earrings. But to them, I was still just a kid. One woman in the gallery leaned over and whispered something to the man beside her, both of them smirking. I kept walking. At the front of the room sat Judge Howard Creighton. Thick jowls, gray hair combed back like he was auditioning for an episode of Matlock, except meaner. His robe looked like it had been folded wrong and thrown on in a rush. He didn't even pretend to smile. His eyes narrowed as soon as he saw me. "Miss Monroe," he drawled, each syllable slow like honey, but with none of the sweetness. "Do you even understand what you're being accused of?" He didn't wait for my answer. He didn't want one. "This is a court of law, not a school disciplinary board," he added. "You can't charm your way out of this with a debate team speech." A few people laughed. It wasn't loud, just enough to remind me that the room wasn't on my side. I looked around. Older white faces mostly. Ties, pearls, wrinkled foreheads, and tightened lips. One man in the back, he couldn't have been more than 30, shook his head like I was already guilty. But I didn't shake. "Yes, Your Honor," I said quietly. "I understand the charges." Creighton blinked, clearly surprised I had a voice. "You sure?" he said, his eyes narrowing. "Because this isn't child's play. This is felony territory. You're facing real consequences here." He expected me to fold. They all did. That's what made this so predictable. "I'm aware," I answered. Another chuckle from the gallery. Judge Creighton leaned back, tapping his pen against the bench. "And who in their right mind told you it was a good idea to represent yourself?" I glanced at the empty chair beside me, the one where a court-appointed defense attorney should have been. He never showed up. "I wasn't given a choice," I said. Creighton scoffed. "So you think you're just going to walk in here, no lawyer, no training, and talk your way out of this?" I didn't answer. Not yet. He took my silence as surrender. He smiled, just a little, just enough. "Well then," he said, picking up the folder on his desk. "Let's get this over with." Judge Creighton didn't waste time. As soon as he skimmed the front page of the file, he dropped it onto the bench like it offended him. "Mr. Dandridge, proceed," he muttered. The district attorney stood slowly, as if stretching out the moment. Mark Dandridge, a man so clean-cut he looked like he shaved twice a day. His tie was perfect, shoes polished like mirrors. And he carried himself like a man who'd never lost control of a courtroom. because the system had never forced him to. He shot me a sideways glance before stepping forward, a smirk tugging at the corners of his mouth. "Ladies and gentlemen," he began, his voice syrupy and over-rehearsed, "this case is as straightforward as they come." He turned toward the judge with a little half-bow. Miss Monroe, a minor, was found on the premises of Eastridge Data Systems with unauthorized access credentials and a personal flash drive containing encrypted files linked to the company's internal server. It wasn't the truth. It wasn't even close. But it sounded true, and that's all he needed. The gallery nodded along like he was a preacher reading from scripture. He continued, pacing like he owned the courtroom. "We're not dealing with a harmless prank. This was intentional, calculated, and dangerous. Eastridge handles sensitive client data. The breach triggered a federal review. And who do we find standing in the middle of it all?" He turned to me dramatically. "A teenage girl with no legal training and no explanation." I stayed still. My hands rested flat on the table. My jaw was locked. "Your Honor," Dandridge added, "we're requesting that bail be denied. Given the technical sophistication of the breach and the defendant's potential access to further systems, we believe she poses an ongoing threat to digital infrastructure." That got murmurs. Creighton looked pleased. "Duly noted. And how do you plead, Miss Monroe?" "I haven't seen the full discovery file," I said. "That's not an answer," Creighton snapped. "I can't enter a plea until I know what I'm pleading against." He leaned forward, his eyes narrowed. "You'll answer the court properly, or I'll hold you in contempt." There it was, the moment they wanted, the tightening of the rope. Make me flinch, make me bend. "I plead not guilty," I said clearly. Dandridge raised a brow, amused. "Noted," the judge grunted. Dandridge was just warming up. He slid a page from his folder and held it up like a magic trick. "We have security footage of Miss Monroe near the restricted data server, time-stamped, and showing what appears to be unauthorized use of equipment." He waved it toward the judge like it was the smoking gun. Additionally, she refused to give a clear account when questioned by campus security, and again during her initial detainment. He turned to me again, theatrically. "Miss Monroe, did you or did you not access confidential files from Eastridge servers?" My fingers curled around the edge of the defense table. "I declined to answer without reviewing the chain of custody for that footage," I said. He laughed. "Chain of custody? That's rich. Where'd you learn that phrase? TV?" No one else laughed, but he didn't care. The joke wasn't for them. It was for the record. Judge Creighton folded his hands. "You seem unusually versed in legal terms for someone with no representation." "I read," I said simply. Creighton's eyes narrowed again. "Miss Monroe, I will remind you that grandstanding will not serve you in this courtroom. If you continue this performance, I will revoke your right to speak and appoint counsel to represent you." "You never granted me a right to counsel," I replied. "I requested representation last week. No one showed. Twice." He frowned. That part wasn't in the script. Dandridge jumped back in. "Your Honor, this is a tactic. She's attempting to delay proceedings with procedural nonsense. The state is ready to proceed." "I'm trying to defend myself," I said, louder now. "You keep calling me a danger to infrastructure. I've been locked up for 5 days without access to a phone. Where's the threat? The only breach here is the system failing to follow its own rules." Creighton banged the gavel once. "Enough. Sit down, Miss Monroe." But I was already sitting. I'd never stood. I watched the prosecutor pace like he was winding up for a knockout punch. Mark Dandridge thrived on rhythm. Every statement sharpened by pauses, every glance calibrated to keep the gallery spellbound. He held up another document, this one in a red folder. "Your Honor, we also have a statement signed by the defendant during detainment. In it, she appears to admit knowledge of system access points, server language, and employee login behavior." He turned to me with a grin. "So tell me, Miss Monroe, do you still claim this was all a misunderstanding?" My hand was already halfway up. "Objection." The word dropped like a bomb, loud, clear, unapologetic. The room froze. Even Dandridge paused mid-stride, caught off guard like he'd misstepped in a dance he choreographed. Judge Creighton blinked, then tilted his head toward me. "Objection?" he repeated, like he'd never heard the word from this side of the courtroom. "Yes, Your Honor," I said, voice steady. "The prosecution is misrepresenting the content of the signed statement." "That's speculative. Also, no legal counsel was present during the interrogation, making the statement inadmissible." Dead silence. The kind that sucks the air out of your lungs. Dandridge's lips parted like he had something to say, but couldn't find it fast enough. "That's highly irregular," he finally managed, shaking his head. "She's not an attorney. She can't just—" I can, I said firmly. I'm the only one at this table representing me. That grants me standing to object under Rule 103 of the Alabama Rules of Evidence. The entire courtroom stirred like someone had thrown open a window during a storm. Judge Creighton stared at me with narrowed eyes. How do you know about Rule 103? I read the state's procedural handbook while in holding, I said. His jaw clenched. Miss Monroe, this is not a law school mock trial. You're walking a fine line. Then let's walk it together, I replied. But if we're talking about admissibility, I'd like to file a motion to suppress the statement, Your Honor. Creighton looked stunned, like he couldn't decide whether to laugh, rage, or recuse himself entirely. This is ridiculous, Dandridge muttered. This hearing is turning into a circus. No, I said. It turned into a circus when the court allowed a teenager to be interrogated without legal representation. Creighton banged the gavel hard. Order. We will maintain decorum in this courtroom. He turned to me. Miss Monroe, your objection is noted. The court will review the circumstances of the statement's acquisition. In the meantime, I suggest you refrain from playing lawyer. I stared at him evenly, and I suggest the court refrain from pretending I'm too naive to know my rights. That earned a few gasps. One man in the gallery straightened up. A woman whispered, "Did she just say that?" To no one in particular. But I didn't flinch, because the moment I said objection, the power balance cracked, even if only a little. I'd interrupted their rhythm, made them hesitate. That was the opening I needed. Dandridge didn't recover well. He went back to his table, flipping through papers faster than his brain could keep up. His next words came out mumbled, unfocused, stripped of confidence. I watched him, calm quiet, not because I was fearless, but because fear had no use anymore. It had gotten me nowhere. Judge Creighton adjusted his glasses and exhaled like he'd aged 5 years in 5 minutes. Let's move forward, he muttered. Mr. Dandridge, continue, if you can. Everyone could feel it in the room. The energy had shifted. Judge Creighton leaned back slightly, his hands folded, his jaw twitching like he was chewing on a thought he didn't want to swallow. Dandridge sat stiffly, arms crossed, his folder now just a prop in a play he was no longer leading. And me? I sat still, calm, watching them realize that the script they'd been rehearsing didn't fit anymore. Creighton cleared his throat. Miss Monroe, you seem unusually prepared for someone without legal representation. Let me ask you directly, where are you getting this information? I tilted my head slightly. Which part? Rule 103. The procedural handbook. Motions to suppress, he snapped. This isn't casual reading. I let that sit for a second. Let the silence stretch just long enough. Then I said, I passed the California bar exam last year. Silence. Not the shocked kind, the disbelieving kind. Like the room had been holding its breath and forgot how to let go. Dandridge actually laughed, one dry, empty note. What did she just say? Creighton's eyes narrowed. Miss Monroe, are you claiming you're a licensed attorney? I'm not claiming, I said. I am. Another beat of silence. Even the gallery, who had been murmuring since the first objection, fell completely still. Creighton leaned forward, fingers steepled now. Do you expect this court to believe that an 18-year-old girl is a practicing attorney? No, I replied. I expect this court to verify it. My name is Ariel Monroe, bar number 423591, licensed by the State Bar of California. I graduated high school at 15, completed my pre-law coursework online, earned my JD through an accredited remote program, and passed the bar at 17. He blinked. Once. Twice. Clerk, he barked, turning suddenly. Verify that immediately. The clerk startled, then began typing like her fingers were racing her thoughts. Dandridge stood abruptly. Your Honor, this is absurd. She's a child. She shouldn't be allowed to self-represent, let alone pull legal stunts like... I didn't pull anything, I cut in. I followed protocol. And when protocol failed, I held the system accountable for its gaps. The clerk looked up from her monitor, her face pale. It's true, she said softly. Ariel Monroe is a licensed attorney, admitted to the California bar on June 14th of last year, active status. The courtroom erupted, not in sound, but in tension. People shifted in their seats, eyes widened. Someone whispered, no way, like a prayer they didn't believe in. Dandridge took a step back, then forward again, floundering. That doesn't change anything. She's still the defendant. This is a courtroom, I said, standing for the first time, and every person in it just assumed that I was too young, too black, too quiet to understand the law. I looked at the judge. But you were wrong. His lips pressed into a thin line. You should have disclosed your status. I did. When I was first brought in, I stated my credentials. They laughed, told me not to make jokes. The officer in booking removed the line from my report. A flash of something, regret, recognition passed across his face. And yet, I continued, despite that, despite being denied counsel, misrepresented, and belittled, I still chose to walk into this room and fight the case on its merits. I turned to Dandridge, and I still haven't heard a single piece of admissible evidence tying me to a crime. Even after my credentials were verified, even after the air in the courtroom shifted like someone had opened a window in a locked room, Dandridge clung to the script like a drowning man clutching a page of instructions. He didn't understand yet. This wasn't about theatrics anymore. It never had been. This was about the law. Your Honor, I said calmly, I'd like to begin by addressing the prosecution's key exhibits, specifically Exhibit B and Exhibit D. Creighton nodded stiffly. Proceed. I stepped toward the defense table, picking up a folder I'd prepared days ago. Tucked between a paperback version of the Federal Rules of Evidence and my mother's annotated casebook from law school. Her handwriting still lined the margins. It steadied me. Exhibit B, I began, holding it up for the court to see, is the surveillance footage allegedly showing me inside Eastridge's restricted data center. Dandridge jumped in, louder than necessary, which it does. Allegedly, I repeated without even looking at him. But the footage has no timestamp, no confirmed camera location, and more importantly, no audit trail. I handed the judge a printed report. Your Honor, I had a forensic analyst, an independent one, review the metadata from the prosecution's video file. This is their signed assessment. It confirms that the footage was extracted from a local server, not the company's secure archive, and the file properties were modified after the alleged incident date. Creighton took the pages, scanning with a frown that deepened with every line. I could see it in his eyes. Something had cracked. He wasn't just listening now, he was reconsidering. The lack of chain of custody, I continued, means the footage is not verifiable. And according to Alabama Rule of Evidence 901, the prosecution must provide evidence sufficient to support a finding that the item is what they claim it is. They haven't. Dandridge looked like he wanted to speak but couldn't find a foothold. I moved on. Exhibit D, I said, is the written statement I allegedly gave during detainment. I held up the document, then placed it on the bench. This statement was extracted after I was held for 9 hours without access to a phone or legal counsel. I requested a lawyer 3 times. Each request was either ignored or mocked. Creighton glanced up. You have documentation of those requests? Yes, I replied. Booking audio from the holding facility. I've submitted the relevant timestamps to the clerk this morning. He turned to the clerk, who nodded silently and handed him a CD and transcript. The statement, I continued, also contains factual inaccuracies that no one has addressed. For instance, it claims I confessed to accessing the server from a terminal in Lab 4B, but I've never even been inside Lab 4B. The facility's logbook for that day shows no entry under my name or student ID. I handed him a printed copy of the log, certified by the university. I'd also like to point out, I added, that the statement spells my last name incorrectly, 3 times. Someone in the gallery actually chuckled, but I didn't smile. I wasn't here for applause. Creighton set the documents down slowly, carefully, like they might explode. He looked at Dandridge. Mr. Dandridge, do you have a rebuttal to these claims? The prosecutor's face was crimson now. He stood but wavered. We were given the footage by Eastridge's IT team. We assumed it was sourced properly. You assumed, I said quietly. That's not the same as verified. The legal system doesn't run on assumptions. Dandridge looked ready to boil over. Your Honor, this is turning into a cross-examination. No, I interrupted, this is turning into accountability, and the prosecution isn't ready for it. The room was so quiet, I could hear the slow hum of the overhead lights. I turned back to the judge. I'm not asking to be treated differently because of my age or because I earned my law license earlier than most, I said, but I am asking to be treated fairly. What's happened so far, being detained without counsel, the mishandling of evidence, the lack of proper verification, none of that meets the standard of justice. Creighton exhaled slowly. Miss Monroe, you're walking into very serious territory. I know, I said, and I'm walking with the law beside me. He didn't respond, not yet, but I could see it. His posture, the way his hands were no longer clenched. He was listening. Finally. There's a silence in courtrooms that doesn't come from quiet. It comes from doubt. I could feel it now, seeping through the cracks of the oak-paneled walls, tightening in the space between words, between glances. Not just hesitation, something deeper, suspicion, but this time, not aimed at me. Judge Creighton sat straighter in his chair, but his hands betrayed him. They were no longer steepled with confidence, just folded, tense. He didn't interrupt me. He didn't even frown. He listened. For the first time, he listened. "Let's be clear," I said, voice even. "I'm not standing here asking for sympathy. I'm not here to spin a sob story. I'm here because the state brought charges against me that don't hold up under scrutiny." I turned slightly, eyes sweeping the room. And if this courtroom is going to pretend to value justice, then it has to reckon with the fact that its own officers, detectives, clerks, even prosecutors, failed to follow the most basic rules. No one laughed this time, not even Dandridge. He shifted uncomfortably in his seat, his jaw locked, eyes fixed on a point somewhere near the judge's nameplate. His confidence had begun to crack. Good. Creighton tapped the armrest of his chair once, twice, then leaned forward. "Miss Monroe, the court is considering your motion to suppress Exhibit D while we await transcription review. Do you have further argument to present?" "I do," I said. "Let's talk about Exhibit F, the data pulled from the USB drive that allegedly links me to the breach." Dandridge perked up. "The drive was in her backpack, Your Honor, found during intake. And logged improperly," I added, cutting in. "There's no photographic record of the evidence bag before transfer. No chain of custody signature from the arresting officer. And most importantly, the file structure on the drive does not match the server architecture at Eastridge." I handed over a printed page from my forensic report. "Your Honor, these files were copied from a system using a Linux directory. Eastridge runs exclusively on a secured Windows-based enterprise environment. That's a mismatch." Creighton blinked. "You're suggesting the drive was planted?" "I'm saying," I replied, "that the evidence doesn't support the narrative. Someone wanted it to fit. It doesn't." A murmur rippled through the gallery. I could feel it. People who had walked in, convinced I was just another arrogant teen, now whispering something else entirely. Creighton turned to Dandridge. "Do you have an explanation for the file mismatch?" Dandridge's mouth opened, closed. He flipped through his binder in silence. I didn't need his answer. I already knew it. So did the court. "This isn't just about me," I continued, my voice quieter now, but sharper. "It's about how easily we let procedure fall apart when the person standing in front of us doesn't look the way we expect." That one landed. I saw it in the way the judge blinked, the way the gallery shifted in their seats. The silence that followed wasn't empty. It was full of weight, the kind that only builds when truth starts making itself undeniable. "I'll be submitting a motion for dismissal," I said, "based on prosecutorial misconduct, compromised evidence, and violation of due process." Creighton nodded slowly. Not agreement, but acknowledgement. Then he looked at Dandridge. "You've had ample opportunity to establish credible grounds for these charges. So far, what I've seen raises serious concerns." Dandridge looked cornered, like a chess player who realized too late that every move was a trap. Creighton turned back to me. His tone had changed. "Miss Monroe," he said, "please submit your motions in writing by end of day. This court is suspending evidentiary proceedings until further notice." It was subtle, not a declaration of victory, but it was a pause, a shift. And shifts are how earthquakes begin. By the time court resumed, I wasn't the one on trial anymore. Sure, my name was still on the docket. But the moment the judge suspended evidentiary proceedings and the gallery shifted its weight toward me instead of away, something fundamental had flipped. Now, it was the system under cross-examination, and I intended to question every inch of it. "Your Honor," I said as I stood, "before the court proceeds with further motions, I'd like to call attention to the conduct of the arresting officer, Detective Jason Merrick." Creighton raised an eyebrow. "You intend to challenge the validity of the arrest?" "More than that," I replied. "I intend to question its integrity." Dandridge was already on his feet. "Objection, Your Honor. This isn't a hearing for police conduct." "It is," I cut in, "when that conduct directly compromised due process." Creighton paused, then nodded once. "Proceed. Keep it factual." I turned to the gallery. According to the initial arrest report, I was detained at 3:42 p.m. in the Student Center after campus security flagged me as suspicious. What's not in the report is that I was held for 47 minutes before any Miranda rights were read. No camera footage of that hallway was submitted into evidence. Why? Dandridge shifted again, but I wasn't done. Also missing, I continued, is the body cam footage from Detective Merrick, who failed to activate his device until after I was placed in cuffs. Conveniently, the footage begins right after I refuse to sign a waiver to counsel. Creighton's jaw flexed. I stepped closer. Your Honor, I subpoenaed internal memos from the Eastridge PD through a public records request. What I found was a misconduct complaint filed against Merrick 6 months ago for coercive tactics used on another minor. The complaint was quietly dismissed without internal review. No external oversight, no inquiry. The gallery was dead quiet. I'm entering that report into the record. I handed the copy to the bailiff, who delivered it to the judge. Dandridge stammered, Your Honor, these are unrelated. They're a pattern, I snapped. And when patterns emerge, we investigate. That's what courts are supposed to do. Creighton scanned the report, then set it down carefully. This court acknowledges receipt of the document. We will review its admissibility. I turned back to the audience. Let me ask a question that no one here has bothered to ask. Why me? A hush fell over the room again. I was never flagged by the university before. Never had a single disciplinary mark. No prior complaints, no pending violations. Yet the moment someone accessed a system they shouldn't have, someone assumed it had to be me. My voice dropped lower. And why? Because I built a network that outperformed the school's own infrastructure? Because I helped professors find vulnerabilities in their platforms? Because I was the youngest black woman ever accepted into Eastridge's computer science honor track? The weight of those words settled like concrete. I was useful to them until I wasn't. Dandridge's voice came low, forced. That's conjecture. It's motive, I replied, and motive is fair game. Creighton didn't stop me. He just watched. You want to talk about integrity? I said. Then let's talk about how this courtroom received fabricated evidence from a school that stood to lose federal funding if their systems were exposed as insecure. Let's talk about how a detective with a history of misconduct was assigned to this case, and no one thought to question it. Let's talk about how this entire process, from arrest to evidence handling to courtroom decorum, has been guided not by law, but by the assumption that I didn't belong here. I walked toward the bench now, slow, deliberate. This court has the power to dismiss this case, but it also has the responsibility to ask the harder questions. Why did this happen? Who let it happen? And how many times has it happened before to someone without the credentials to fight back? Creighton finally spoke. His voice wasn't loud, but it was sharp. Miss Monroe, this is my courtroom. You're here to present a defense, not to put the entire justice system on trial. I didn't flinch. With all due respect, Your Honor, the moment the system turned its back on fairness, it put itself on trial. I'm just asking the questions it refuses to answer. There's a difference between silence and shock. I'd heard both in this courtroom, but what came next was something else entirely. It was the sound of a system choking on its own assumptions, trying to breathe in a reality it never expected. Your Honor, I said, with your permission, I'd like to enter one final exhibit into the record. Something recently obtained. Creighton studied me for a moment, cautious now. Go on. I pulled a sealed envelope from my case file and handed it to the bailiff. Exhibit H, a digital trace log from the university's internal server. Dandridge scoffed. More speculation? No, I said flatly. Proof. Creighton opened the envelope, skimmed the first page. His eyes narrowed. This is a network log, he muttered, time-stamped, IP specific. It details the login credentials used to access the Eastridge faculty databank 2 days before the alleged breach. It came from an administrator account, not mine. Dandridge stepped forward. Objection. This wasn't submitted in pretrial discovery. Because it didn't exist in the pretrial window, I shot back, it was deleted. Scrubbed from the university's network, but a systems librarian named Joel Cantrell, who previously managed infrastructure audits at Eastridge, reached out to me after the last hearing. He recovered this from a legacy backup server no longer connected to the mainframe. I looked directly at Dandridge. The account used in the breach belonged to someone else. A faculty member, Dr. Jonah Keene. Gasps, audible now even from the jury box. Creighton's brow furrowed. You're accusing a tenured professor? I'm presenting the facts, I replied. Dr. Keene oversees access to student project archives. He also sits on the disciplinary review board. He had both motive and means. Dandridge's face flushed. This is character assassination. This is digital forensics, I snapped. And if you'd done your job, you'd have found it before trying to prosecute me. Creighton tapped his gavel lightly, once, twice, not to silence me, just to steady the room. This log does appear to contradict the prosecution's timeline. I nodded. Because the timeline was never built on facts, it was built on assumptions, and now that assumption is falling apart. Creighton turned to Dandridge. Did your office investigate faculty access logs? Dandridge fumbled. The IT team assured us. You never checked, I interrupted. You were so eager to close the case, you ignored alternative access points. You ignored digital footprints. You ignored motive. The judge sat back slowly, his face a study in reconsideration. Then he looked up. Is Mr. Cantrell willing to testify? I nodded. He's in the building. I asked him to come. A moment passed, then two. Finally, Creighton sighed. Call him. The bailiff opened the side door, and a man in his 40s walked in, awkward but determined. Joel Cantrell, wire-rimmed glasses, blue windbreaker, a stack of printed documents under one arm. He raised his hand and swore in. Creighton gestured for him to begin. Cantrell cleared his throat. I was part of the IT team at Eastridge until last year. I maintained redundancy logs on an external node as a personal precaution after a malware scare. When I heard about Ms. Monroe's case, I checked the archive. He held up the printed logs. I found a trace of the breach activity. It didn't come from her account. It came from a faculty machine logged in under Dr. Keene's ID. Dandridge tried to object. This is hearsay. No, it's not, Cantrell said calmly. It's verifiable. You can pull metadata from the node. IP trails don't lie. Silence again, but this time it was different. This time the silence wasn't resisting truth. It was yielding to it. Creighton spoke last. His voice was quiet, but it carried like thunder. This court will recess for 30 minutes. During that time, I will review this new evidence in full. Counsel for the prosecution will prepare a response. And Ms. Monroe, he looked at me now, longer than before. You may have just changed the direction of this entire proceeding. I exhaled slowly. I didn't smile. Not yet. But the system had finally blinked. There's a moment in every war when one side knows they've lost. Not because the flag drops, not because the enemy retreats, but because the silence changes. When court reconvened, that silence was everywhere. The gallery was no longer whispering. No side comments, no stifled chuckles. Just eyes locked forward. On me, on the prosecution table, on the judge. The only sound was the ticking of the courtroom clock, like a countdown no one dared to stop. Judge Creighton walked in slower this time. Less rehearsed, less controlled. He settled into his chair, looked down at the documents Cantrell had submitted, then up at Dandridge. Mr. Dandridge, he said, voice level but heavier than before, you've reviewed the forensic material provided by the defense. What's your official position? Dandridge's tie was askew now, his collar slightly damp. Your Honor, the prosecution wasn't aware of this backup log until today. We need time to verify its authenticity. You've had hours, Creighton interrupted. You're not disputing that these are legitimate metadata records, are you? A pause. No, Your Honor, Dandridge muttered. That was it. The moment it all cracked. I sat still, calm. But inside, I felt something shift. Not just in the case, but in the room itself. A turning of gravity. The weight wasn't on me anymore. It was on them. Creighton continued. The court has reviewed Exhibit H and finds it materially relevant, credible, and corroborated by sworn testimony. Based on this, the foundation of the state's case has been severely compromised. Dandridge opened his mouth, then closed it again, like a man watching a house collapse that he helped build. I am ordering a formal suspension of all active proceedings until an evidentiary review can be completed, Creighton went on. Furthermore, I am filing an inquiry with the Office of Judicial Oversight regarding potential prosecutorial misconduct and evidence suppression. Gasps. Again, only sharper this time. Dandridge's face went pale. His co-counsel leaned in, whispering fast, panicked. But Creighton wasn't finished. This court recognizes that what has occurred here today is more than just a procedural misstep. It suggests a deliberate neglect of duty, one that could have permanently damaged an innocent person's life. He turned to me, and for the first time in this entire proceeding, I saw something in his eyes that hadn't been there before. Respect. Miss Monroe, he said, do you have anything to add? I stood, and I didn't gloat. I didn't grandstand. I didn't smile. Because this wasn't about winning. It was about surviving truth long enough for the world to see it. Yes, Your Honor, I said. I have one thing. I turned, facing the gallery, not the judge, not the lawyers, the people. The ones who came in doubting me, laughing at me, brushing me off like I was some kid who wandered into grown-up business. The system isn't broken, I said. It's working exactly as it was designed to work, for the privileged, the protected, the ones it was built to serve. The rest of us, we're just collateral, unless we know the rules, unless we fight back. The room was frozen, so I finished. Don't clap for me, I said. Look harder at what almost happened here, and ask yourself who else never got the chance to speak. I sat down. Creighton cleared his throat. This hearing is adjourned pending further investigation, he declared. Miss Monroe, you are released under full dismissal of charges. This court will reconvene only for review of institutional conduct. He struck the gavel once, just once, and the room let out a collective breath, like air after fire. But I didn't breathe yet. Not until I walked out of that courtroom. When the courtroom doors closed behind me, the world outside was louder than I remembered. Flashing lights, dozens of cameras, reporters pressing forward like waves crashing against a dam, and in the middle of it all, me. No podium, no legal team flanking my sides, just a 19-year-old girl with a worn-out satchel and a throat full of fire. I didn't expect the crowd. I didn't expect the chance, but I recognized the look in their eyes. The look people get when something they never believed could happen just did. Miss Monroe, Ariel, do you have a statement? What do you want to say to the court? How did you pull this off? I took a breath, not to center myself, but to choose carefully what I would leave behind. Because that's what this was now. Not just a verdict, a legacy. So I stepped forward. No microphone, no script, just my voice. You asked how I did it, I said. But maybe the better question is, why did I have to? That stopped them. I continued. I had to defend myself because the system wasn't built to protect me. I had to prove my innocence because they never gave me the presumption of it. I had to know the law better than the people sworn to uphold it because no one expected a girl like me to survive it. Flashbulbs blinked, silence hovered. I didn't win today because I'm special. I won because I refused to shut up. I refused to shrink. And because I read every page of the law they tried to use against me. I saw heads nodding now, some tearful, some stunned. This country tells young black women like me to sit down, be quiet, wait our turn. But today I stood. Today I spoke. And I didn't wait. A cheer rose from the edge of the crowd, then another and another. But I raised a hand, not to silence them, but to shift the focus. This isn't just about me. It's about every kid who got labeled too loud, too smart, too bold. Every student who got sent to detention for being curious. Every girl who was told she didn't belong in the courtroom unless she was in handcuffs. I let that hang. I stood up because I had the knowledge, but I shouldn't have had to do it alone. The noise began to swell again. A name started forming in the crowd. Ariel, Ariel. But I didn't let it take over. Instead, I looked straight into the nearest camera. And to every young person watching this, especially the ones who've been told to stay in their place, I want you to hear me when I say this clearly. Know the system, master it, use it, because no one can silence you if you know how to speak in the language they fear most, truth. Then I stepped back, not because I was done, but because I knew what I came here to do was already done. As I turned to leave, someone handed me a single folded note. I didn't see who. I opened it later when the noise had faded. It said, "Thank you for proving we're not crazy for asking questions. Anonymous, 11th grade, Eastridge High." That one sentence hit harder than any gavel ever could, because it meant the echo of what happened today was already moving. I'm not naive. I know this wasn't the last fight, but it was the first time the silence didn't win. And maybe that's enough to start something bigger. Ariel Monroe's story is more than just a courtroom drama. It's a reflection of the world we live in. It shows how easily systems can overlook, dismiss, or even silence those who don't fit the mold. A young black woman, underestimated and denied the basic right to be heard, stood her ground not with outrage, but with knowledge, precision, and undeniable truth. What this story reminds us is that change doesn't always come from power. It often comes from the courage to confront power. Ariel didn't fight the system with noise. She fought it with facts. And in doing so, she reminded all of us that justice isn't automatic. It has to be demanded, protected, and constantly re-examined. This story is a fictional narrative created for educational and entertainment purposes. It is not intended to target, defame, or criticize any real person, organization, or institution. Any resemblance to actual events or individuals is purely coincidental. If this story made you think, feel, or reflect, Share your thoughts in the comments below. Let us know what you would have done if you were in Ariel's place. And if you believe stories like this matter, please like the video, share it with others, and subscribe to the channel for more. Let's keep the conversation going, because the more we speak up, the harder it becomes for injustice to hide.